Oh, this is your lucky day because we are here with Colleen Flynn of the Johnson Pope Boker Rupel and Burns Law Firm, the second best law firm in Clearwater, Florida, to talk about two items that she is very, very adept in, and that is shielding employers from liability. We'll mention that. That's not a concern to anybody, right? And then the amazing vaccine mandates. Colleen, what is a mandate? Is
A
that when you go out with a guy, a mandate?
mandate means you must do something. So, just like we mandate that, our employees wear shoes to the office, we can mandate other things as well as employers, provided that we don't run afoul of the law depending on what state we sit in.
Yeah, that's the mandate. No open-toed shoes because something may fall on your foot and hurt you.
And it's just unprofessional, really, to be barefoot at work.
Right, right. Well, the manicure places got that law not passed because then no one would need the pedicures anymore. All right, so Colleen, let's go ahead and look at these slides.
Yeah. So here's what we're going to discuss today for a half hour. We get lots of calls and emails about, people have heard about vaccine mandates. People in Florida hear about the Florida law that Alan and I talked about last Monday that says you can have it subject to 5 exceptions. There are then other mandates floating around out there. Most of you have heard about the OSHA mandate, the test or vaccine mandate. There's a government contractor mandate for vaccinations. There's also a CMS, the Center for Medicare and Medicaid Services mandates out there. Now, those are all currently in various stages of litigation that we're going to talk about. So we're going to do a quick recap of vaccine mandates and then just talk about those 3 federal mandates that are currently stayed and what we should be doing to not only watch for them, but start planning what we would do or how we would implement them if in fact they are upheld and we have to start implementing them. I would say for my CMS certified medical groups out there who are, surgery centers, not just you accept Medicare and Medicaid, but that you're actually a certified Medicare and Medicaid provider where you get inspected by the state, it's ACCA in Florida. Those folks are subject to the CMS mandate. So let's just review quickly these first slides. But the one thing I can say to all of you is keep watching. Right now, you may not have to make any changes to what you're currently doing, but please keep watching because it could come and it could come quickly. So under federal law, before we had our Florida law a few weeks ago, so if we have people who are out of state, depending on what your state law is, this is the federal law. So federal EEO law allows vaccine mandates for employees physically entering the workplace. No problem. However, we still have to make accommodations for religion or disability, which could include pregnancy-related conditions that constitute a disability. And that would be, and we can go to the next slide, and these would all be accommodations that are just like you guys do whenever anybody wants a disability or religion accommodation. So remember, disability accommodations, we require individuals with disabilities to meet the safety standard. But if an employee can't meet it because of a disability, we have to go through our regular analysis. We have to determine whether we could make a reasonable accommodation or whether there is such a direct threat that we can't. So if somebody says, I have a disability, a medical condition that I can't get vaccinated, then you go through your normal analysis. I think that right now you'd be very hard pressed to not be able to find some kind of accommodation based on what we're seeing. But there could be a situation. There are certain medical jobs or people treating, clients with infectious diseases that maybe you can't. I don't know. Maybe it is a direct threat, but these are all individualized assessments. I cannot tell you on this, webinar today in half hour whether you could or couldn't make an accommodation. You need to go through that analysis just like everything else. All right, next slide, Alan.
Okay.
Okay. So this is what we look at, just like anything else, when we try to determine whether people are a direct threat, duration of the risk, nature and severity of the harm, likeliness of the harm, the imminence of the harm. But, in most situations, we may be able to put the person in a separate office. They can wear a face mask or a face shield. They can be separated. it's likely for someone with a disability we could accommodate, but again, case by case basis. And I do also think it depends greatly on the physicality and the physical circumstances of the workspace. So if I needed an accommodation for a disability and I couldn't get a vaccine, I'm in my office. It's plenty big. There's no one in here. I have my door closed. I'm not a direct threat to anyone. If I walk down the hall to go to the restroom, I put my handy mask on wherever it went. And so I could probably be accommodated in this situation. But, if you're at a job where you're in a very small physical environment, then perhaps there would be a direct threat. But again, case by case. Okay, next slide. So again, these are just the accommodations that we could look at. Potential accommodation: require the employee to wear a mask, work a staggered shift, let the employee telework, reassign the employee to a different job that maybe that job has its own workspace. There's lots of things we could do to accommodate somebody who has a disability and is medically unable to get the vaccine. Okay, next one. All right, so again, religious accommodation, same thing under Title VII that we always deal with if somebody wants a religious accommodation. Now, this is under federal law. Remember, from last week, we discussed that once somebody fills out the Florida form, it's a different situation. So generally under EEO law, there's no magic words for the request. They have to tell you that they have a religious conflict with something related to the vaccine or a particular vaccine. And under federal law, you can make a bit of inquiry, but if you're my Florida folks here, we cannot. Once they fill out the form that says it conflicts with a sincerely held religious belief, we're done. But under federal law, it is a bit different. So for those of you sitting out of state, remember this is federal law, but you should also check with your local attorney to see if there's any state laws like we have in Florida that override these federal accommodations. Okay, next slide.
Okay, so just make it clear, if you're a Florida employer, don't worry about the federal religious belief exception, because the Florida law tells you, if they told you that this is a religious issue, you can't question it. You're done.
Correct. Once they fill out the forms that we all looked at last Monday on our lunch webinar, if they fill out that form in Florida, they're done. You have to accept the form. You cannot ask them about it. I'm sure people have seen, other forms, or they've seen other states where people, ask about why do you have this conflict? Is your conflict to all vaccines? Is it to just this vaccine? Have you had other vaccinations? In Florida, we cannot do that currently. If we have a vaccine mandate, if someone fills out the form, that's the end of it. So let's click through, Alan. Maybe let's see what the next couple slides are. Okay, so let's just go a little faster. Let's go to the next one so we can kind of cover all this stuff. Okay, so again, even under Title VII, it applies to non-traditional religious beliefs, things that may be unfamiliar to you. But under Title VII, we have more leeway than we do under the Florida law. But just like under Title VII, the Florida law, it doesn't, non-religious concerns or just my personal preference isn't what the issue is. You must attest under Florida law that you have a sincerely held religious belief, not that, I have a political belief that I don't want it. So that would be a different situation, and it is not protected either under Florida or federal law. Okay, next slide. So what do we do with all these things? Okay, we can click through these because I think we've talked about these, most of our employers. So, we talked about best practices. So here's what we can talk about that applies both under federal and state. Before you institute the mandatory vaccine policy, please be certain you understand what law covers you. If you're in Florida, we've got those 5 exceptions that we talked about last week. If you're in a different state, understand this is the federal law, and then check and see what other state laws might apply to you. You want to make certain that you're training the employees who are responsible for communicating with this so that they understand what the law is, so that they're not saying something incorrect to your employees. Remember, you can always implement policies regarding social distancing, masking, modified shifts. You can always discipline employees who aren't following your safety protocols if they're not wearing their mask or they're not wearing their mask properly. That's not something that for private employers is talked about under federal or state law, and you do have the ability to enforce mask rules in your office. And we have mask rules here that when you do leave your office, you put your mask on to go down the hall or to speak with other employees. So you have that right, and you have that right to discipline people who aren't following your safety rules in the workplace. Okay, next one. Let's see. So again, we want to make certain that we have the proper accommodation request form. So if you're in Florida, you need to use those, and you have a mandatory vaccine policy, then you're going to need to use those 5 forms that we looked at last Monday. If you're in a different state and you don't have a state law and you only have to follow the federal law, then you will probably just want to use the EEOC forms that we linked down there to you. Now, those are really just the general religious accommodation forms under federal law, but they work perfectly for this as well. Remember, for whatever state you're in, if you're having a vaccine mandate and you have medical information on your employees, it must be stored separately. And you may keep it, of course, but you must store it separately. Okay, next slide. So here's some other issues that people are asking us about. So you're not going to have a vaccine mandate if you don't want to, and that's fine. But you can still inquire and request documentation that the employee obtained the vaccination. That can be useful in determining protocols, and you may need to know about if there's an exposure to determine who needs to quarantine. Because remember, the CDC guidance on who needs to quarantine is dependent on vaccination status currently. Now, of course, like anything else, that could change. But currently, there are different rules for somebody who's exposed who is vaccinated and somebody who's exposed who is not vaccinated. Now, that does not apply if somebody's having symptoms. It just talks about exposure. Also, that's useful information for accommodation requests, et cetera. So you can ask that information, got to keep it confidential. Okay, you can also incentivize employees to get vaccinated. Now, let me back up. The cards and whatnot, those need to be kept confidential. Of course, somebody may figure it out if people are talking in the workplace. You can't prevent employees from talking about their own vaccination status, but we shouldn't be disclosing people's vaccination status or anything medical to go along with it. People may figure it out if certain people have to quarantine after an exposure, or certain people have to wear masks if your policy would say vaccinated people don't. But, you need to keep it confidential as an employer. The EEOC does allow us to incentivize employees. There's nothing currently prohibiting that in federal law or in Florida state law. The EEOC has somewhat of a nuanced answer, though. It says, yes, provided that if the vaccine is administered by the employer, so let's say I'm in medical practice and I'm going to administer it to my own employees, then the value of the incentive may not be so substantial as to be coercive. But if the provider administering is not the employer, then the ADA doesn't necessarily limit the incentives offered. So, if you tell your folks, go to the grocery store or CVS or wherever, and if you show me your vaccine card, I'll give you a $100 gift card, that's not a problem. Or if I will give you an extra day off in your PTO bank, whatever the case may be, that's fine. If you have a policy, then you want to reward people. It's completely fine. We also hear lots of talks about HIPAA. I'm not telling you, it's not HIPAA. Okay, HIPAA does not prohibit you from asking about vaccinations. HIPAA regulates how protected health information is used and disclosed. Doesn't prohibit asking, okay? It only regulates how somebody uses that information. Because I think we've all heard that. I don't have to tell you HIPAA. All right, so Florida. If you were with us last Monday, we went through the Florida issues. In Florida, businesses cannot deny a customer or client access based on COVID-19 vaccination status. However, there are challenges to the law by a cruise line. There has been an injunction granted in favor of Norwegian Cruise Line, banning that application. That is currently on appeal by the state of Florida, but as probably most of you have heard, Norwegian mandates that you be vaccinated to get on to one of their cruises, and they filed a lawsuit trying to stop the law application to it, which says that a business cannot deny a customer or client access based on vaccine status. And the Florida court said, no, this is a public safety issue. And at least with respect to cruise lines have an overriding public health and safety issue that is also governed by the federal law and those federal sailing orders. And those federal sailing orders have the vaccination requirement in there. So right now, if you want to go on a cruise on Norwegian Cruise Lines, then you need to be vaccinated to go. And there are also testing requirements, et cetera, that have been upheld Now that currently is on appeal, and we'll see what happens, but right now that is an exception to the Florida law that prohibits businesses from denying customers or client access based on COVID-19 vaccination. Now don't forget, as a business, you can still require your customers to wear a mask.
So was this in the last week that Norwegian Cruise got this?
This was over the summer, this case.
Okay. All right.
Yeah. So it's currently up on appeal. Florida has appealed that. Now remember, there are prohibitions on local governments and educational institutions from vaccine mandates for employers or people entering the premises. So that is what it is for our local governmental entities. And then just a recap, if you missed it last week, if you want to have a vaccine mandate for your employees in Florida and you're a private business, you can. However, you have to offer 5 exemptions: medical reasons, to include pregnancy and anticipated pregnancy, religious, and you cannot ask about the sincerely held religious beliefs. You just, once the religion form is signed, that's it. You have to offer an exception if somebody can prove COVID-19 immunity with an antibodies test, as we talked about, or if the employee agrees to the periodic testing no more than once a week and it's at the employer's cost, and if the person agrees to wear the employer provided PPE. So, you know, really they're giving people an out if they don't want to be vaccinated. But I still get back to, you can always have safety protocols in your office. I've had lots of calls with clients who say, oh, my employees tell me that you can't force me to wear a mask. Well, as of right now, if you're a private employer in Florida, you can absolutely require people to wear masks if they're your employees. And you can absolutely have a vaccine mandate. However, you have to allow those 5 exceptions.
Colleen, really the first 3 exemptions don't matter anymore, because the 5th exemption, the employee just says, I don't want it, I'm not going to get vaccinated, I'll follow your PPE rules, right? So the first 3 are irrelevant now, I think, right?
For practical purposes, Alan, you're right.
And then the 4th one here is, okay, they're not vaccinated, you can pay for them to get tested up to once a week.
Correct.
To make it a little bit harder for them to not be vaccinated.
Less pleasant. Now, bear in mind that generally federal law trumps state law. So should these other mandates we're going to talk about in a moment get implemented and those apply to you, then that would supersede, this Florida law. But to the extent, though, that you're not covered by one of these other mandates that we're going to talk about, which are going to be CMS, CONTRACTOR, or if you fall under the OSHA, then yes, the Florida law is what you follow if you're sitting in Florida.
We used to call it Trump, the one law would trump the other, but we can't say that anymore.
Yes. Supersede. Okay, so with the 3 issues right now of the federal vaccine mandates, the first one is the federal contractor vaccine mandate. And so this mandate required employees of federal contractors and subcontractors to be fully vaccinated by December 8th, which was last week, with limited exceptions only to those entitled to accommodation. So those were only entitled to a legal accommodation, which is disability and religion. Okay, so it was only those 2. Let's see, there were also in that law mask, physical distancing requirements, covered work sites, all those kinds of good things that, you know, that we've been hearing about for safety issues. In order to be covered, it had to be a contract, not a grant. And it clearly states that the requirements are pursuant to federal law, and thus they would supersede any contrary state or local laws. So there is, if you are a federal contractor and you are listening, there is currently a nationwide preliminary injunction in place that covers all 50 states, the District of Columbia, Puerto Rico, and the Mariana Islands. So this vaccine mandate is currently stayed. It is not being enforced, and federal agencies will not take any action to enforce it, but contractors working on site in government buildings still have to follow whatever those COVID-19 safety protocols are for those businesses. And on December 9th, just last week, the federal government, the Biden administration, appealed the injunction. And so there are, you know, there's lots of challenges to it. So we'll see what happens. It's currently up on appeal. So if you're a contractor, keep watching.
Or move to Guam.
True. All right, let's see. What's our next slide show us, Alan? The OSHA vaccine or test mandate. Okay, so this is the one that most people heard about on the news and are most familiar with. So the OSHA ETS, which means Emergency Temporary Standard, requires private employers with 100 or more employees to either mandate weekly testing or COVID-19 vaccination by January 4th. So for any employee who wasn't fully vaccinated, in addition to testing, they had to wear face coverings when indoors or in a vehicle with another person for work purposes, except while alone in the room with floor to ceiling walls. So none of this, you can sit in your cube and take your mask off. And while limited eating and drinking, you can take your mask off, or for identification purposes to pull your mask down for security, or time clocks that do facial recognition. So the OSHA ETS is very dense, and my group here at my firm, we put on a fairly lengthy seminar on it on Zoom a few weeks ago, of course, right before it was staged. And so there are lots of ins and outs, but again, at the end of the day, it's not a vaccine mandate, it's a test or vaccination mandate. This law is interesting, or this ETS is interesting, because it says that the testing is at the employee's expense, which is a little bit different from the Florida law, and gives employers maybe some incentive to say to their folks, hey, please get vaccinated. You won't have to come do this test every week. So we're waiting to see. Again, on November 6th, the Fifth Circuit temporarily stayed the mandate. Then on the 12th, they extended it, claiming that it exceeded OSHA's statutory authority. And so the stay is currently nationwide. And so there then, because all these different states filed lawsuits to try to stop this, there was then a lottery system as to what circuit got to hear the appeal. And so the lottery, every circuit gets a number. And so then they pulled it out. And right now the Sixth Circuit is the winner. And so the Sixth Circuit is currently handling the OSHA vaccine or test mandate. And the government has filed a motion to lift the stay. So we'll see what happens with that. Right now, it's just bogged down in litigation. There's nothing that has happened probably since last week. If we go to the next slide, I think we can see that, let's see. On December 7th, the government filed a motion to lift the stay, and they had until Friday to file a reply. And then we're going to wait and see what happens. So Friday, the government filed their reply, and we will wait and see. But I don't think necessarily that we're going to hear the end of it, regardless of what the Sixth Circuit says. I mean, whoever loses is going to bring this to the Supreme Court to review that Sixth Circuit decision. So we'll wait. Down below, I see I have a typo. I said December 9th, 2022. That should say 2021. There was a resolution passed to repeal the OSHA mandate by the senators. But again, it's only a symbolic gesture because they don't have any practical impact on that, because that was an OSHA rule promulgated by federal rulemaking. So they basically said, we don't like it either. Okay, then our last vaccine mandate is the CMS mandate. So CMS issued a vaccine mandate, and that requires all eligible staff at healthcare facilities that are CMS certified facilities be vaccinated. And it would have required full vaccination by January 4th. We got a lot of calls on this one because it only applies to the CMS certified facilities, and there's a list of who that covers. So, surgery centers, that was the clear one. There are some physical therapy places that are certified as CMS rehab centers. So it will only apply to those folks. So they're after the initial scramble of people thinking, oh my goodness, I take Medicare, is this going to apply to me? It didn't, and it doesn't. It applies only to those certified. And this law is very tight. I mean, it says that exemptions are only permissible based on a recognized medical condition and sincerely held religious belief. And it had a form and a statement. And in the rule, there's a statement that the doctor has to explain why they believe that, in their medical opinion, it is contraindicated, and based on what. It was not just a quick statement, and it's putting the doctor who is signing the form, putting their reputation on the line as well. It also allowed for a delay for vaccination if somebody is recovering from COVID-19 following whatever the CDC recommendations is at the time for the time between recovery and vaccination. Like I said, it required extensive documentation, and you could ask those religion questions that we talked about under the federal law that you can't ask under Florida law. They stated that they would enforce this by state survey agencies during your recertification survey, and they would assess the vaccination staff on complaint surveys. So there's a record keeping requirement that you keep a copy of the vaccinated folks, the date of their vaccination. You keep a record of who's on delay. You keep a record of who has an exemption, the reason for their exemption. And so that when ACCA, if you're in Florida, or whomever comes on site to certify you or do their survey, that you're ready and you have all that information. Now, this one is taking an interesting procedural turn for those of you who may be, law nerds, but there have been multiple challenges to this CMS mandate in different courts. So initially, Florida was quick, and they filed a lawsuit down, I think it was in South Florida, attempting to get a preliminary injunction against this. And guess what? Initially, Florida denied that injunction, saying, nope, seems reasonable, it can go into place. Okay, but then, next slide. There are two other cases, Missouri and Louisiana. And the Missouri and the Louisiana courts, after Florida said, nope, it can go into place, it's fine, they then entered preliminary injunctions prohibiting the mandate. And the Louisiana ruling applies nationwide. I believe the Missouri one applied to like 10 states. And then the Louisiana one says, you know what, I'm going to apply this to all the country. So in Florida, the CMS mandate is still not enforceable because of the Louisiana ruling, regardless of the Florida ruling. The government, CMS, has appealed to the Fifth Circuit trying to appeal the nationwide injunction. But in the meantime, in a very interesting turn of events, the state of Florida still appealed the loss to the 11th Circuit despite the nationwide injunction. And they asked the 11th Circuit to rule. And guess what? The 11th Circuit upheld the denial of the injunction and refused to impose the injunction pending appeal because they said that Florida failed to make the requisite showing that an injunction was appropriate under these circumstances. The 11th Circuit held that the vaccine mandate was authorized by Medicare and Medicaid statutes. They had good reason for bypassing the notice on the rulemaking, and CMS adequately considered all relevant aspects before considering it. They also said that Florida had not proven irreparable harm if the CMS mandate went into effect, and that the balance of harms and the public interest did not warrant the pending appeal. So basically, our Florida courts and our 11th Circuit has said, no, the CMS mandate can go into effect. But because the Louisiana court said this applies nationwide, we still have to abide by that nationwide rule. Now, interestingly, there are motions and things pending in Louisiana, and the reason that Florida appealed and thought that they could get the 11th Circuit to overturn the lower court is because they were concerned that on appeal of that Louisiana nationwide injunction, that the Fifth Circuit may say, no, it only applies to Louisiana and the other states who brought this case, not nationwide. So Florida was trying to jump the gun and get them to say, if that limits it, we still want it to be in place. But that's not the case. So if something happens in that Louisiana case and they reverse the nationwide mandate, in Florida, it's in place. However, CMS has said while this litigation is going on, that they're not going to be enforcing it. But this is definitely the one to watch, especially if you're a CMS certified entity that this covers, because our 11th Circuit has already, said, we think it's okay. We don't think there should be an injunction. So their opinion, which was close to 100 pages, gives the federal government, an argument on its behalf, whereas, the other cases that have come down have been all on the side of staying it and not enforcing it.
Colleen, what's your guess on how long it is before all the courts decide?
It's interesting that we say this because there have been requests for expedited rulings and requests for expedited hearings. And so sometimes those have been granted and sometimes they have not. I believe right now in the Fifth Circuit, I think on the OSHA test mandate that they have not ruled on the request for the expedited hearing. So it could take some time. So while these things are stayed, yeah, this is not going to be decided possibly for a little bit, but we're just going to have to wait and see. I mean, last week things were changing rapidly, but at this point everything is fully briefed, and now we'll wait and see what happens.
Okay.
We go to the next slide. So what do you worry about? What do you do? I mean, this stuff is crazy. I was talking to somebody else on the phone earlier this morning, and I said, it's been a long 2 years at this point. We think we know the law one day, it changes the next, it goes back the other way, and then something else happens. You know, in October, we were all feeling pretty good, like we were getting out of COVID. Now people are worrying again. And as for my employers on here, the I-9 rule about remote verification ends the end of this year, 12/31. So now you're back to regular I-9 verification rules, no more remote. So, and remember, anybody you verified remote has to get verified in person again within 3 days, either after the rule expires or after they return to work. So, yeah, things are happening and very quickly. So what do you do about these vaccine mandates? I mean, I've had people call me, you know, just throwing up their hands, and I get it. But currently, all of the federal mandates are state. Obviously, this could change, so please keep watching. I suspect, and this is my gut, that these federal agencies are not going to be enforcing them, even if if they go up on appeal to the Supreme Court, they're going to, you know, even if right now they could enforce them, I think they're going to wait and see. But I don't know. Some of these, if the Fifth Circuit reverses and says that, you know, the nationwide injunction's off the table, we'll see about the CMS, about what happens with that one. So keep watching. If I had a crystal ball, I'd be very, very wealthy. I could have everybody's you know, policies in place on the right day, but we just don't know. And so the other questions we get are, how is this intersecting with Florida statutes, or if the state law prohibits mandates? I mean, generally, the supremacy clause of the Constitution applies. Federal rules preempt state law. But, you know, as a Florida employer, you're caught between a rock and a hard place between these federal mandates for noncompliance and also penalties under state law. We don't know, since this is all new and we've never seen it before, what the state of Florida could try to do with respect to enforcement and penalties, even if your defense is, I was complying with federal law, because we know about the tensions there these days. So there definitely promises to be litigation, you know, over these conflicts of state and federal law. So keep watching. We're going to do our best to guide you through it and to keep everybody out of you know, harm's way with litigation. But some of these things are just so new. We are just all, you know, trying to use our best judgment as we navigate these for unprecedented times. So the one thing you can do in the meantime to start prepping is that you can start analyzing what applies to you. So figure out, okay, am I even covered by CMS, or can I just ignore this one? Can I ignore the contractor one? What do I have to worry about? If I'm in Florida and I have 30 employees, the only thing I have to worry about is the Florida law, okay? If I'm in Florida and I have 150 employees, what do I worry about? Well, if you're a law firm, you worry about the OSHA and you worry about the Florida law, okay? If I'm in Florida, I have a CMS certified surgery center, and I only have 42 employees at my surgery center. Okay, well, right now you're going to watch the CMS, see what happens with that. If that never gets enforced, then you're going to just stick with the regular Florida law. Okay, if you are a surgery center and let's say you have 200 employees, then you have 3 rules to worry about. You have the CMS rule, you have the OSHA 100 rule, and you have the Florida rule. But the one that's most restrictive is what's going to apply to you. So at the end of the day, if CMS goes into effect, that's what you're going to apply. You're going to have to comply with, because the OSHA one will be superseded by the CMS rule. If the CMS rule goes by the wayside and you have 200 people and you're in Florida, then you're going to worry about the OSHA and the Florida law. And those, as we've discussed, have conflicted, and will, you know, federal law generally supersedes state law. So we'll see how that goes. So I think the biggest thing is you probably want to continuously be updating and analyzing your safety protocols, you know, collecting the information on the vaccine status. Once you realize what could apply to you, you probably just want to think through what you want to do. And if you're an employer and you have 25 employees in Florida and you're not a CMS or a government contractor and you don't want to have a mandate, you don't have to have a mandate. But if you do have a mandate, you have to follow the Florida law. So keep watching, because these things are coming fast and furious, and it's very confusing for everybody.
Okay, so if you have any questions, you can email Colleen directly, or you can email me, agassman@gassmanpa.com. Colleen is much smarter than me, so I would really ask her, not me. Colleen, COLLEENF, @jpfirm.com. So we'll come back as soon as these mandates get lifted or unlifted or stayed or unstayed, and when they enjoin the injunction, it's going to be a lot of fun. Stay safe. Colleen, any last words?
No, just keep watching and let us know if we can help you.
Okay. Thanks so much. Have a
Thanks,
great
guys.
day.
You too. Bye-bye.